Good afternoon, everybody, and thank you for joining us today as we talk about the intermediate track. Just by way of brief introduction for those who don't know me, my name is Sophie Walmsley. I'm one of the barristers in the personal injury team, and I'm joined by Alastair, who is also one of the personal injury barristers in Chambers. Today we're going to be talking through a whistle-stop tour of the intermediate track, and we're going to be looking at what it is, what it means, the complexity bands. We're also going to go through a few case examples and what that might look like in terms of banding, as well as some of the issues around allocation, reallocation and reassignment within the complexity bandings before talking about the cost sides of things as well, and looking at practically some tips that you can adopt in making claims that are progressing through the intermediate track a little bit more streamlined and make a little bit more sense. So, without further ado, I'm just going to get started on some of the general background. All of this will be fairly familiar to you all. So, in personal injury litigation, we're looking at the intermediate track where the cause of action, so the accident, etc., happened on or after the 1st of October 2023. There are a little bit of some differences if it is a disease claim, but that's the key date that we're all working with now. The major difference that was created by the rules, as you all know, is now there is allocation to track, including the intermediate track, which acts as a bridge between what was the fast track and the multi-track. But within that, if you're allocated to the fast track or to the intermediate track, what complexity banding you are going to be assigned to. And that's significant in terms of costs, but also in terms of the litigation itself. Now, as you can all probably appreciate, especially given the newness of some of these provisions and how we're seeing them come into play, there is likely to be and has been some disagreements and discrepancies about not only allocation, but banding, and so courts are and will likely continue to be very involved in those decisions, and there is a discretion for the court. It's a little bit more lax in the intermediate track for the court to have a hearing to either hear about allocation or about banding. Just in a point to note, the court doesn't actually have to agree with the banding that might be put forward by the parties. And so just because you might agree on something doesn't necessarily mean that the court will. And of course, there will be the ability for the court to set directions, and it will set directions. Now, after that sort of generic background, I'm just going to go through a quick recap. So as we all know, 4 major tracks: small claims track, usually looking at damages less than £10,000, personal injury, different limits for different types of claims, but generally under £5,000 or under £1,500. There are less stringent rules in the small claims track, both on evidence and expert evidence. And then you look at your fast track claims, so less than £25,000, usually a trial estimated of no longer than 1 day. Some limitations on the expert evidence, although we routinely see in the fast track cases where there's lots of expert reports, albeit it's unlikely that there will be oral expert evidence given. And then we come to the track that we're concerned with, which is the intermediate track. So this is a claim with a value of less than £100,000, with a trial length generally no more than 3 days. And you can have oral expert evidence. There's no limit in terms of expert reports, but there is a suggestion that oral expert evidence should be limited to 2 experts per party. Now, how the court is actually going to stick to that remains to be seen, and I think it's interesting that the rules say that it's likely limited to 2 experts per party. And then finally, for those claims that are not suitable for the intermediate track, fast track or small claims track, we still have the multi-track. Interesting provision, and I've just drawn attention the slide about what it says about clinical negligence claims, appreciating that that's not necessarily relevant to personal injury practice, but it does seem quite stringent in terms of whether a clin neg claim will be suitable for the intermediate track, just noting that there would need to be some admission not only of breach but also of some loss and limitations in terms of what defences are raised. I've highlighted some of the key provisions within the respective rules. The important thing to note if you're trying to get your head round the intermediate track is that you can't just look at one part of the CPR. You're going to have to look at multiple sections. So rules in Part 26 are obviously apparent, Rule 28 and Part 28. You are also going to have to look quite carefully at Part 45 because there's some interesting provisions in there which we are going to come on to discuss. So the next thing that we're just going to talk about as a brief overview, aside from the issue of allocation, which is the usual sort of things that you're looking at, complexity, nature of the dispute, the amount of financial compensation in question, expert evidence, all of those things. The thing that's more likely to be controversial is not necessarily whether it is suitable for the intermediate track, it's where it's going to fall in the intermediate track. So Alastair and I are going to have a bit of a discussion now about these different bands and what it says, and I'm just going to pass over to Alastair first for some of his comments about what the banding suggests.
Well, I think the first thing to note is just that last point about what it suggests. There's not really that much in it. And given the fact that there are very few cases that have actually addressed the specific banding itself, it is very much still a Wild West. The important things to note, particularly when we're looking at Band 4, what does it mean by serious issues of fact and law? And then also, where are you going to be able to move it up from a Band 1 to a Band 2, a Band 3 to a Band 4? And noting that in reality, Band 2 and Band 3, there's not going to be much of a difference in terms of the overall cost that you're going to get.
One of the things I found quite striking when these rules came out, and still looking at them now, is it's not necessarily what it does say, but what it doesn't say.
Yeah.
And I mean, when you think about, Band 1 seems fairly straightforward enough in terms of having one issue in dispute. So you'd expect this to kind of catch your RTAs, liability admitted, just sort of generic issues about quantum. But then when you get into, you can still have some quite complex RTA cases, particularly where the medical evidence might not be clear. And I always find it quite surprising that the banding structure for the intermediate track is actually less detailed than the banding structure for the new fast track complexity banding. And it doesn't touch at all on employers' liability cases other than highlighting that, for example, in Band 3, other EL disease claims. So I suspect it's been kept vague deliberately so. But I think one of the difficulties that we see in practice is that it's so vague that you end up with a case that could quite reasonably be allocated to one of a number of bands, and it is going to come down to how a particular judge is going to view a particular set of facts. And in the absence of any real guidance that has been given, either in the CPR or in any of the case law, the lack of case law at the minute dealing with this, when you look at Band 4, what is a serious issue of fact or law? It seems to demand a level of complexity and seriousness, but then doesn't go that step further of saying what that might be. And that is something that I think we're going to see as we go through these case examples.
Yes, and I think the other thing to bear in mind is, first of all, there is also one glaring omission in terms of the complexity banding, and that is that it doesn't mention, obviously it's about complexity, it doesn't mention what the value is. So you can end up having a case where the value is going to be about, it could be £99,999. Ordinarily it would be a multi-track. If you have a case where liabilities admitted, it might be a bog standard credit hire, it can quite easily end up in Band 1. It
is curious on that point that value doesn't seem to feature explicitly at all in the complexity banding. Now, they're not always synonymous with each other. Just because something's more valuable doesn't necessarily mean it's more complex, and vice versa. But sort of the logical deduction that I think people might have was, well, if it's tipping more toward the upper end of the intermediate track limit, surely that commands a level of complexity to it. Because, for example, even in a straightforward RTA claim, say liability has been admitted, but the quantum side of things is quite complex, not necessarily from a medical evidence point, but say there's quite a complex loss of earnings claim. You're self-employed, they just started a business, you're looking at getting evidence in respect of that. Yeah, okay. But I think that's something that would tip more upwards in terms of complexity banding. But because it doesn't allow any express provision in terms of the value and what that might mean, it leaves a lot of doors open.
The other two, a couple more points. First, in terms of complexity, I suppose the question is what is meant by complexity. You can have a case that seems relatively straightforward on the surface, and there may be issues that are not central to the case itself, but they are nonetheless relevant. For example, the vulnerability of the claimant, which can always add to complexity, even if the underlying claim is not that complex. So I suppose the question is, what does complex mean here? How is that going to affect the banding? The other point is, again, this is the complexity banding, the assignment. It's very, very unclear, very uncertain. As a result, it's quite easy to imagine how it's going to be very dependent on what an individual judge is thinking at any given time. You can end up going to one court and it might be perhaps not complexity band 1 and one is complexity band 4, but nonetheless, given that there is such a difference between some of the bands, such as 1 and 2 and 3 and 4, which judge you have and the arguments you make on any given day can make a huge amount of difference, particularly as not to jump the gun a bit, because we're going to address it later on in the presentation, but reallocation, reassignment now is much more difficult.
It is, and sort of with those complexity bands in mind, we're going to just turn to some examples. So the first example involves a claimant in an RTA accident on the 26th of September 2023. Liability for the accident was admitted, minor soft tissue whiplash injury that had been agreed pre-issue in line with the tariff. But there was quite a significant credit hire claim, so £91,000 for the hire costs, all of the usual issues in dispute, enforceability, rate, impecuniosity. And there was mention in the pleadings about the personal injury element, but it didn't seem to be properly carried through. And here, I suppose the first question is, were that suitable in terms of allocation? And sort of spoiler alert, because this is a real case, there had been an argument made initially at the allocation hearing that the court shouldn't have even been concerned with the intermediate track because the personal injury element of the claim was before that key date of the 1st of October. So we were looking at the older system in terms of fast track or multi-track. And that seems to have been the point that was taken and in essence conceded by the defendant at that hearing, with the judge then deciding, okay, well, because of the value, this is not suitable for the fast track and it needs to be on the multi-track. Now, that naturally got appealed.
Yes.
And I suppose the first point, and you and I have very different views on this in terms of where it should have ended up and where it does end up. But my view on most credit hire cases is, whilst there are arguments about law, they can be quite sort of document heavy just because of all the terms and conditions, etc. They're fairly simplistic in their arguments realistically, and the value might be a bit of a red herring here, because you look at the value and you think, oh, well, that's definitely up there toward the end of the limit. But the issues are fairly straightforward, and when you look back to what the banding actually allows for, I mean, band 1, in my view, pretty much ends up on all fours here. There's one issue in dispute, it's quantum realistically, and it's an RTA non-personal injury claim. So it seems all in all something that was quite rife for intermediate track allocation, and definitely at the absolute lower end of the banding.
I think this is where this question of which judge you get really does play into come into play quite a lot. The other point, even though the banding doesn't mention the level of damages at all, it's easy to imagine a situation where you face a judge with, well, this is a claim worth £91,000. Obviously, band 1 is going to not be appropriate. The other thing to bear in mind, whilst we've got 7 bullet points making the facts of the case relatively straightforward, when you go into the weeds of it, you can sometimes find that, yes, a credit hire can often be a credit hire, but once you have £91,000 worth of credit hire, that is in and of itself very unusual, and it can introduce complexities all of its own. But it's very easy to see how you can have it. The fact that we're able to have an argument over it and say, well, do you think it's band 1? Do you think it's band 2? Indicates that the rules aren't that clear.
No, and sort of the outcome, because this is a case that was reported, it's called Holland and Zurich. It's a county court decision from Liverpool heard on appeal. But in essence, what the court decided in that case, and this deals more with the transitional aspect of the intermediate track than sort of purely looking at allocation and assignment, was that the personal injury event, given that had been essentially settled beforehand and hadn't been properly pleaded, meant that this was a non-personal injury claim. It was held that the judge quite properly should have considered the intermediate track, and that it was probably suitable for band 1. And again, I think this case, to me, when I was reading through it, highlighted how difficult this is working for practitioners and judges in applying these rules, particularly where you can have claims like this where there's both a sort of an earlier PI component and a credit hire component, and what happens in relation to it. As I say, my initial thoughts when I was reading through the facts of the case was band 1 did seem to be appropriate, but you can see realistically the arguments being made as to, well, it certainly doesn't get to a band 3 or a band 4, but potentially could get into that band 2 category. So that's the first sort of scenario that we're analysing. The second is another sort of made up scenario, which is an employer's liability case. And this is where me and Alastair really butt heads in where we say that this should be allocated in terms of complexity banding. So as you can see, generic facts, 16th of November, claimant was employed, shelving unit fell on top of her, sustained some not insignificant injuries, claim pleaded at £75,000, liability and quantum in dispute, several expert reports, some not so straightforward injuries from the neurological and spinal point of view. Defendant says suitable for complexity band 2. Claimant says band 3. I will say, just for sort of with my defendant cap on, I mean, again, when you sort of think about what the issues are here, I don't see there being that much in terms of complexity on a factual or a legal basis. It seems like a fairly bog standard employer's liability claim. Even the medical evidence, whilst there's multiple experts, doesn't strike as being a particularly complicated case. Not that much realistically. I still think the trial could be heard in a day, possibly 2. I don't see any real complexity here that, in my view, would push it into band 3, even though it's an employer's liability case. I think, again, it's a bit of a red herring when you boil it down to sort of simplicity. This case quite realistically could be a band 2, but I know that you strongly disagree.
Yes. Well, the first thing to note is it's an employer's liability claim, and again, when we're looking at the rules surrounding the banding, it doesn't really mention whether there is a difference to be applied. But in my experience, I would tend to find that, for example, cross-examination in an employer's liability claim is always going to be a bit more protracted than in an RTA, where you can have one, driver two, you're probably not going to have any other witnesses. Whereas in an employer's liability claim, you're probably going to have maybe 2 or 3 different witnesses from the employer, and then you've got the claimant as well. So just on liability alone, and whilst I note that we can see that perhaps where a shelving unit falls on someone at work, that might be more straightforward. That is a case of it's more straightforward, but it's certainly not going to be straightforward overall. And that's liability. So liability is still in dispute on this one. And then when you're looking at the quantum evidence, we've got 3 different experts. There's a maxillofacial. So whilst and I would say all of them to a degree, well, maybe the maxillofacial surgeon is a bit less complicated, but you've got the post-concussion syndrome from a neurologist, you've got the spinal surgeon where there's a slightly complicated prognosis. On quantum alone, it's going to be complicated. On that basis, I would say it feels more like a band 3 than a band 2.
And I think this is just an example of how a lot of these cases can be quite borderline between 2 different bands. Although the point I think we both make in due course is the practical difference between a band 2 and a band 3 is not all that significant when you compare to some of the other sort of bands. And so I can see there being an argument that, well, there's more than one issue in dispute here. It's not so straightforward that it's captured by a band 2. I think this sort of comes into making sure that when you are looking at what potential complexity banding you're going to be pitching for, that you give it quite considerable thought, because there will be, more often than not, these quite borderline cases. And as we will come on to, it's really important to get it right as soon as you can, because otherwise the process becomes a little bit more difficult. I do think, though, as you highlighted in terms of this factual matrix, that might have a degree of simplicity to itself, in the sense of evidence-wise. It's unlikely there's going to be lots of lay evidence. You're just going to be looking at the same thing that most employers' liability claims look at: risk assessments, working procedures, etc. But you could very well see there being an inconsistency in terms of one judge perhaps deciding this is a band 2 and another judge deciding that this was, for example, a band 3.
I think one thing that's quite interesting, though, is if we were to change the scenario, keep liability the same, but this time, at this stage, we've only got an orthopaedic surgeon that's been instructed, and other evidence is pending, but we don't have it. We don't have it yet. I would say it would be very much band 2, and then once it's in band 2,
you might get stuck.
Yes.
So this is just sort of an overview of the points that we've just made and some of the things to think of when you're looking at cases and where they might end up in terms of complexity banding. Is there more than one issue in dispute? Also think about the nature of that issue. Most people often think that quantum, it's a straightforward thing. Quantum can be the most complex aspect of a claim. The fact that it tends towards a higher value is not in and of itself something that's going to push it up in terms of the boundary, like the banding. We're looking at complexity. We're not necessarily looking at value. They may go hand in hand, but not always. How many expert disciplines have been engaged or are likely to be engaged? Think about your length of trial. The reason I say that is because band 1 is the only one that sort of specifically sets out that it should be capable of being dealt with in a day. So if you're looking at 1 or more days, it's not exclusive to that, but just have a think, because something that's going to likely take more time to get through in terms of evidence is perhaps an indicator of its complexity, and then perhaps an indicator of why you might need to be looking at these higher complexity bands. Does the extent of the nature of the injuries or the expert evidence just in and of itself mean that it's unsuitable for intermediate track allocation? It's really important to identify as soon as you possibly can, and ideally before you get allocated to the intermediate track, if you think that this is a claim that is likely going to be more suitable for the multi-track, for reasons that we will come on to in a moment. But if you think, and it happens all of the time, a claim starts out looking one particular way, but as the evidence evolves and develops, suddenly your £25,000 claim is now a £150,000 claim. The sooner you identify that, in terms of where these new rules leave you, the better. So having a real sort of forward-looking view on where your case is, but where realistically it is going to end up, is going to be key. And the point that we talked about, looking at really trying to delve deep into sort of the factual and the legal issues. Are there any issues of actual complexity here that means that it's going to tend it up or down in terms of complexity banding?
And also, are there issues that are serious?
Exactly. And that's the point that we're going to address now, which is, okay, well, what, if you remember what we had on the slide about Band 4, it referenced serious issues of fact or law. So this case example is an RTA, liability admitted, some expert evidence, psychologist, orthopaedic, but the defendant has raised that it was a low velocity impact and raises fundamental dishonesty. Defendant says liability admitted, not that complex in terms of claim, it would just be evidence from the claimant, medical expert evidence if challenged, Band 1. But then there's this point that is fundamental dishonesty, something that would be a serious issue of fact that might justify Band 4 or some of the higher banding. I'm going to let you start with that because you're more passionate on this than I am.
I mean, I would say that it's hard to think of something more serious than raising dishonesty. First of all, the consequences of it. It's not necessarily the most common thing that a finding of fundamental dishonesty results in criminal proceedings, but it's a possibility. And also, raising dishonesty generally is a very serious issue. It can be that I think there's a bit of a danger that, given that there's an increasing tendency to plead fundamental dishonesty in a large number of cases, sometimes where it's not necessarily made out, that because you flood the pitch with lots of arguments of fundamental dishonesty, judges see it all the time, they think, well, it's just another fundamental dishonesty case. But when you consider what fundamental dishonesty is, what it means to make that argument, it's hard to see how it's anything other than a very serious issue of fact that's been raised. And the other thing to bear in mind is whether or not this could be used to disincentivize allegations of fundamental dishonesty being raised when they wouldn't otherwise be made out. Because at the current stage, there's not too much of a downside. There can be an argument that there's unreasonable costs, but there's not going to be too much of a downside for a defendant raising fundamental dishonesty when it's not made out, whereas the risk to a claimant is far more profound. Whereas if you get to a stage where you're at a directions hearing and that you're facing, a defendant is thinking, do I pursue this argument of fundamental dishonesty that may not have legs? However, there's the risk that we're going to end up in Band 4, or otherwise we drop it and we end up in Band 1. I think it will encourage settlement a lot more.
And unsurprisingly, this is somewhere where I disagree. A lot of you will remember that there was a time that when fundamental dishonesty raised, it sort of inevitably meant that the case would be allocated to the multi-track. We have long since moved beyond that approach, and in fact it is way more common now to see fundamental dishonesty cases raised and dealt with very well in a fast-track one-day trial. The issues of fundamental dishonesty in terms of complexity often don't, the law is pretty settled. It's a matter of evidence. Yes, it means that there needs to be more detailed cross-examination. Yes, there's more preparation and a little bit more work that goes into that. But I think sort of setting a precedent that if FD is raised, that necessarily boosts up its complexity value just doesn't bear fruit with what we have been seeing for several years, which is we can very adeptly deal with FD allegations in the fast track. It would be contrary completely to that to then say, oh, but we couldn't deal with it in the lower banding of the intermediate track.
I suppose there's a couple of points in relation to that. The first is if not fundamental dishonesty, what is a serious issue of fact? Did the people drafting the rules simply use the wrong word here? But also, I'm not sure if my own experience is perhaps uncommon, but I've had a couple of cases recently where it's in the fast track. I've made the point that fundamental dishonesty is going to be raised, and then the judge adjourns it and says this needs to be heard for 2 days because fundamental dishonesty has been raised here. We cannot deal with it so simply.
Yeah. And again, it's going to come down largely to how the judiciary are going to interpret those serious issues of fact or law. I mean, serious issues of law, probably a little bit more straightforward to get your head around, but a serious issue of fact, I mean, the consequence of that, as you say, is quite grave. But just on a pragmatic reality, I just don't see how FD can take it, into either a band 4 or potentially even a band 3, unless the underlying complexity wasn't already such that it justified it.
The other interesting thing about fundamental dishonesty, just in terms of banding itself, is just because of the nature of the law in that area, you can raise it at any stage up to and including, so long as you've raised it in cross-examination and submissions. Obviously, by that point, the banding is already going to be set. Now, occasionally you're going to have a case where fundamental dishonesty is raised at the defence or something like that. But there's then a question of, well, on paper, we have a trial where fundamental dishonesty has been raised. It's going to have to take a lot longer. However, we're already in band 1. Yeah. So that doesn't necessarily match with FD being band 4.
As I say, I think it's an important point to recognise that, and we see it all of the time, even in the fast track, that the amount of additional work that FD creates is not to be understated. And we have seen a stream of authorities recently that have really tried to hammer down on unmeritorious pleadings or raising of fundamental dishonesty. But I think the issue is to what extent that can have any bearing on complexity banding. I can see the argument, I suppose, both ways. I think it perhaps does raise it to some extent, but does it get quite as far? And what's rather unhelpful in terms of the drafting of these rules and the guidance, the lack of guidance, is that we do not have any definition at the moment of what a serious issue of fact may entail. So it's arguable for certain, but whether that argument is ultimately going to land well, I think is going to depend on your judge.
It also just doesn't seem to fit. Because at the end of the day, in complexity banding, you are concerned with complexity. Seriousness is not necessarily the same. So although you may think that, well, if something is serious, it is more likely to be complex, it doesn't necessarily follow that, well, just because there is a serious issue of fact here, that means that ergo it must be a very complex case.
And as I say, I think there's a point of principle, but then also a point of pragmatism. Thinking sort of, again, back to how we see these fundamental dishonesty cases actually being dealt with at the moment in the fast track. You can certainly see that some judges may sit there and say, well, hold on a minute, I hear however many fast track RTA trials routinely in the fast track, and that's capable of being dealt with. Again, I think if that argument needs to tie into sort of the overall complexity, but it's an argument that can be raised because, as you say, what can be more serious in terms of overall consequence? Also impact on the litigation, especially if there's things like surveillance, additional statements, having to go back to your experts to comment on, if there's been searches, etc. That in and of itself would be something. But it's important to really highlight that these issues are very much cutting both ways and sometimes into the extremes. So FD itself is something that I think you need to keep a really close eye on if you're for the claimant in terms of, and for the defendant in terms of actually reflecting, is this something that is going to add to our argument on complexity banding? You know, can we put forward, and should we be putting forward, that because of the nature of the issues that are in play, it has changed the dynamic of the case, it increases the factual complexity, the legal complexity, the time estimate, the nature of evidence, the amount of evidence, such that it would be inappropriate to be banded at, say, a band 1.
Yes.
Now, moving on from those examples, we've alluded to it many times about reallocation and reassignment, and we've given quite a lot of warning about getting it right in as much as you can the first time round. I say you getting it, the court getting it right.
Yes, yes.
The first time round in as much as you can. And the reason for that is set out on the slide. So the court can still reallocate and it can reassign to a different complexity band. The thing I found most staggering was the way that the test has been reformulated for reallocation, particularly for those claims allocated to the intermediate track. So it used to be that the court may subsequently reallocate, so very discretionary, very little by way of guidance in the white book on it. But now, if you're on the intermediate track and you're seeking reallocation and directions have been set down, which they inevitably will have been, you can only reallocate if there are exceptional reasons for doing so. And you may all be looking and thinking, okay, well, what is an exceptional reason? Which is a fantastic question that the people who have written the rules book haven't deigned to expand upon or answer at this point in time, with no real support from authority either. It's the exceptionality side of things that causes me a bit of concern, because, I mean, I would usually think, well, there'd been a significant change in value or landscape, or again, perhaps even an allegation of fundamental dishonesty has now been raised. There's lots of surveillance evidence. We need to go back to our experts and things of that nature where it boosts the complexity so much so. But I found that particularly troubling, and I'm just sort of curious as to whether you agree with that.
I mean, I have had a couple of cases that were in the intermediate track and have since been reallocated. My view... and again, who knows, maybe this is a judge-by-judge approach. Maybe it's a case that because it's so early on in experience of the intermediate tracks that perhaps the courts aren't necessarily following the correct test, especially if there's not clear guidance. But certainly in those cases, it didn't seem that there was an exceptional reason. What it was upon review of further evidence, the value was a bit lower. Now that seems to me to be a lot more like the old reallocation test. So I'm just wondering whether, as sometimes happens, the judges get used to, having been on the bench for a while, they get used to the old rules and they apply the old rules to new provisions when perhaps they shouldn't be.
Yeah, I thought it was quite noteworthy that the wording had been changed in such a way to create this sort of exceptionality aspect. Because, as we all know, your case when you start out and your case when you're sort of moving down through the directions can end up looking very different for one reason or another, be that the value is higher than you anticipated, it might be lower than had been anticipated, there might be issues that have arisen, there might be a need to get, quite a lot of further expert reports. Even such as things like claimant has lost capacity during the context of the litigation. And it seems to have a sort of a hurdle without any real explanation of how, what that actually means is a little bit difficult. We'll come on to in a minute what we sort of understand it to mean. But in terms of reassignment, not quite so stringent as reallocation. So it can reassign where there has been a change in circumstances and where that change in circumstances justifies the reassignment. So a little bit more relaxed. But still, I can see very likely some judges taking quite a bit of convincing that, yeah, okay, well, there's been a change in circumstances, say the value's increased by a certain amount, but not sufficiently so that it's going to justify the assignment. So there's two hurdles to get over in terms of reassignment.
I suppose in a way that makes sense, that there is that difference in how difficult, how high the threshold is for reallocation versus reassignment, given that if you're falling out of the intermediate track into the fast track, the cost consequences are going to be far more significant than if you're falling from a band 3 to a band 2 or band 2 to a band 1. But I think the main lesson is, especially on reallocation, given how stringent it is, especially for claimants, it is important to get your ducks in a row very early on. It applies both ways as well. It doesn't say you can only reallocate to a higher track. It also applies if you're dropping down. So I suppose tactically you really want to make sure your case is as valuable as it possibly can be, so that if it's a borderline case between fast track and intermediate track, you're on the right side of the line.
I think sort of the general takeaway is front load the case and the issues as much as you can, because you do not want to be in a position, I mean, not to say that you couldn't be reallocated, because of course you can be, but you want to try and get it right that first time round, especially because we are yet to see how judges are actually going to be applying these tests now in reality. So just a little bit more on that. What might be an exceptional reason? I mean, the things that came to my mind were, as I say, significant additional complexity, loss of capacity, death of the party, significant changes in terms of the evidence, which renders the complexity higher, pushes it up into the multi-track, significant change in the claim value. Yeah. You know, if you've managed, you know, you've got a report in, your claim's now gone to being, you know, £500,000. Well, it would seem really disproportionate for that to remain in the intermediate track, even if it was on a band 4.
Although that being said, I mean, the current rules or the previous rules were less stringent. However, you would still find that you might have a case that's in the fast track. Claim value increases from, let's say, 20,000 to 45,000, and a judge would think, yes, it's above the limit, but there are other factors to bear in mind, and the court is more than capable of dealing with a £45,000 claim in a day, keep it in the fast track. So for it to be a change in the claim value, it really is going to have to be a significant change.
It's going to have to be worthwhile.
Yes.
Yeah. And change in circumstances for assignment. Okay, so the first thing I thought of, unlikely to happen sort of at that later stage, but say an admission has been withdrawn, so now there are more issues in dispute than perhaps one, additional value, additional complexity.
Raising the issue of FD.
Raising the issue of FD.
FD.
So things like that, they may be the change in circumstances which would justify reassignment. Just important to note, if you're reallocated or reassigned, you start, it's like your initial allocation or assignment didn't happen. Your costs are the costs from essentially what you've been reallocated to. So if you've gone to the multi-track costs from the outset. If you're reassigned from a band 1 to a band 2, for the purpose of calculating your costs, it's from band 2. So drawing it a little bit together before we go on to some of the cost provisions is, how do you make the most of this? And as we say, narrow the issues as soon as possible. There is way more benefit now to defendants trying to, if you've got a case that's a bit iffy on liability, admissions are more likely to reduce the number of issues in dispute and potentially reduce the complexity banding. So have a real consideration about what issues can be narrowed, if at all possible. Because as we'll come on to, the lower bands are the most sort of cost-promising bands from the defendant side of things. Consider the use of your experts and expert disciplines really carefully. If you can, front-load it, because of what we've sort of mentioned, in that they're not that it may end up being a much more streamlined process than the rules would have you led to believe, but the sooner you can identify those things, it's going to help with allocation, it's going to help with complexity banding, and indeed it might assist further if there's got to be arguments made later down the line. We'll come on to this in a little bit more time in a moment, but the vulnerability of a party or a witness It should be identified as soon as possible anyway, and I'm sure that you've all been doing that. It's important because if you've got a vulnerable party or a vulnerable witness, first of all, that's going to be relevant to your complexity banding. But secondly, it's going to be relevant on your costs, which is what we're going to come back to. Draft your DQs and your directions very carefully. Keep your eye on the ball. I think if you are going to be going for reallocation or reassignment, make sure that you've got what you need so that you can get over those hurdles, either exceptional circumstances or you end up in terms of saying, well, it is justified. And just another point that you can have a split trial or a trial on a preliminary issue within the intermediate track, so liability only, or say, for example, there's a limitation point.
And just on limitation, I think given the changes, it means those 3 years feel a lot shorter than they previously would have done, especially especially on that expert's point. The number of times you would instruct a GP, it takes a while to get them to get the claimant to be examined. They then say, we consider that we need an orthopedic expert. There might be an MRI or something. Then you have potentially a psychologist, potentially a pain, and after a while, there's a huge amount of time that's been spent ultimately just trying to flesh out what is the position on PSLA.
Yeah. And again comes to the importance, because you want to be justifying what banding you're saying is appropriate, and you'll be in a better position to do that if you have the evidence. Exactly. Rather than if you don't.
Yeah.
Finally, we're going to talk about costs. I have put some figures up on this slide. The overarching message is it's not as bad as it initially seemed.
No.
It's not brilliant, but it's not as bad as it seems. I've done some calculations taking the guideline hourly rates as they are now, not with the London weighting, I'm sorry, but looking at intermediate track band 1 with damages awarded about £50,000. And you'll see what that works out at in terms of if you had a grade A national one working on that case solely up until trial. It's about 48 hours. It's not, and of course you wouldn't usually have a grade A working on a band 1 all the way through. But as we were saying, realistically, the major financial differences, at least as I've calculated them, is between band 1 and band 2 and band 3 and band 4. So if you're for a claimant, obviously you're likely going to be wanting to push. If you think you're band 1, you might get into band 2. You'd be pushing for band 2. If you're a defendant, you want to push down. And
I think even within that, given that there's that, it feels to me that it's going to be harder to get from a band 3 to a band 4. There's £11,000 of difference. Getting from band 1 to band 2, in my view, is going to be the really the very contentious arguments that are going to be made. It's effectively doubling the amount of cost that you're going to get. And firstly, it's all based on issues, how many issues are in play. And other than that, it's not that difficult to get from band 1 to band 2, whereas perhaps it's going to be a bit harder to get from a band 3 to a band 4.
Yeah, I see the real sort of hurdles is justification into band 4. Perhaps not, again, depends on the nature of the issues. For example, some sort of industrial type case, more, quite complex, multiple defendants, etc. That might end up in a band 4. But yeah, the difference between sort of the earlier bands, band 1 and band 2, is really quite pointed. And again, it sort of draws into front-loading these issues, because the more issues in dispute, the more complex the case gets, the more evidence is. You can see how actually that tracks up quite quickly.
The other thing, just going back to the first point, that fourth bullet point down in terms of what the equivalent is in guideline hourly rates. This is all calculated on a band 1. For a band 4, you're probably looking at about 130 hours.
It's slightly more.
Slightly more?
Yeah. And this is just a baseline. There's additional ADR sort of fees that you get if you have a JSM. I do you think you'll struggle to justify a JSM in a band 1?
Yes, probably.
Potentially even a band 2, but certainly worthwhile thinking as much as you can. Is it worth engaging in ADR? You should be doing it anyway, of course, but there are additional costs that are separate to those that that aren't sort of already included for. So the costs aren't that bad.
Although with the caveat that this is 2026.
Yes, and we are not convinced that they're going to suitably update these in line with inflation.
So we may find in 2036 or 2041 that the costs will start to look a little bit limited.
So finally, just some words of caution when it comes to costs. And the first is Rule 45.9, which is that the court may consider a claim for an amount of costs excluding disbursements where there are exceptional circumstances making it appropriate to do so. Again, there's always very little guidance when they create these tests in terms of exceptional circumstances. I view this to be quite similar to the test that was set out for the previous fixed costs in the fast track in terms of that exceptionality. There's been cases, I think it was Hislop and Purd, that talked about it has to be above the normal swings and roundabouts. Exceptional obviously sets a very high hurdle itself. So again, I think it would be those sorts of things. You know, has this case really been taken out of its norm where it would justify an award above what the fixed costs are? And again, the courts like to keep their powder dry, and the Rules Committee like to keep their powder dry in providing some definitive guidance on this. But it is a provision to be wary of and aware of, because you may consider that actually, you know, something has gone so off-piste, or that, you know, and it's caused quite a significant amount of cost to be incurred above what you would be entitled to ordinarily, that it's worth a punt under 45.9. The next point is the vulnerability, and the reason that we flagged this earlier is it also has a cost benefit, or it can have. So identify it as much as you can. Vulnerability, where that causes additional costs to be incurred because of that vulnerability in the claim, and by reason of that, it's at least 20% greater, the court can sort of look at awarding more than the fixed recoverable costs, or it can look at issues in terms of allocation, etc. So that provision under 45.10 is quite an important one to be aware of. I would say, again, it's not particularly well defined. It asks you to look at the practice direction 1A, have a look at what would be considered to be vulnerability. It's really important to make sure that not every vulnerability is going to sort of fall into that. It's going to have to be something which has impacted the time and the way that the work has been done on the case. But the sooner you identify this, the better it will be, first of all, in terms of allocation and assignment, but secondly, in terms of thinking, you know, we've all seen it where you end up doing a lot more work on a case than you're going to recover in terms of fixed costs. Is this a way to try and recoup?
Yes, and I think that point's quite important, particularly with the 1A, because sometimes you think vulnerability is going to be more like CPR 21. It's not limited to where you're a protected party. It's I think the typical example is someone who doesn't speak English. So ordinarily there's going to be provisions at trial for interpreters, but obviously that's the cost is not limited to getting an interpreter. It's also doing the conferences, speaking with solicitors. It's incurring costs at every single stage, and at the same in the same breath, I suppose, you could say that when you're looking at someone who would ordinarily be a protected party, if they're about 17, there's not going to be necessarily masses more costs than if they're not a protected party. So it is very much it will hinge on the facts of each case.
Yeah. Final point. The provision about unreasonable behaviour, I mean, this has been there. There's a similar provision in the general rules about costs anyway. But what's very striking about 45.13 is that the effect of that is it can decrease or increase cost by an equivalent, the fixed recoverable cost by an equivalent of 50%. Unreasonable behaviour, I mean, again, it's one of those things not particularly well defined. One example might be, although I think both of our experiences of judges take up on this argument to be quite similar, fundamental dishonesty has been raised with absolutely no merit whatsoever. It's been pursued all the way through. That has generated increased costs and things like that throughout the life of the claim. Do you try and go for unreasonable behaviour? I think there was a question that I had actually seen earlier in the chat about delays in establishing issues about indemnity or liability for 2.5 years, forcing people to do additional work. Those sorts of things might be the things that get captured under your unreasonable behaviour. Seeing this, it doesn't give me all that much hope. I imagine it will be applied in the same way it was applied in the fast track and in the small claims track, albeit not very much. But it is there, and again, it's something to be wary of. It doesn't say anything above and beyond what the general discretion over costs is provided for anyway, but it is there specifically, it is captured, it's enshrined, and it can have a very heavy bearing on costs. So it's something to be mindful of if you have concerns about conduct or behaviour. Again, it can be a costly and quite a worthwhile argument to make if it pays off.
Yeah.
So that brings us to the end of our talk. I've seen some questions in the chat, so we will answer some of those. If you have any questions for us, do put them in the chat and we will try and get round to them. So I'm going to just start with, can you claim additional costs in addition to fixed costs under Part 36 for delay in establishing issues about in the indemnity for 2.5 years, forcing claimant solicitor to do additional work, had the third party settled indemnity liability earlier? What are the exceptional circumstances? Examples? I think, again, to my recollection, there's nothing specifically in Part 36 that would deal with that. You're looking at the general provisions around costs and what that provides for in terms of behaviour or unreasonable behaviour. Is it 44.2 deals with it generically? But again, there is that argument that can be made under Part 45 now as to whether that meets the exception, a bit like exceptional circumstances threshold. Again, that's going to be a judge by judge issue. I can see some being quite critical.
Yes.
And on the other hand, I can also see some of being like, well, this happens all of the time, which they shouldn't do. But
I sometimes feel that judges often would avoid wanting to, they would prefer to just follow the easiest road sometimes in terms of costs.
Yeah.
I would have thought that they would avoid making that finding of there's exceptional circumstances. I think it's going to be quite difficult to make that out.
The next, we've had two questions that also ask about contributory negligence and what effect that might have on banding. My view on that is that contributory negligence, it is an issue. I don't think it's right to say that if that's a sort of ongoing point, liability isn't fully resolved, is it? Because you've got to deal with this issue. So I do think that can have an impact on complexity banding.
I would 100% think that if you've got a case where liability is admitted, albeit there is contrib, you're still going to have to do cross-examination on liability. It cannot be in a band 1.
Yeah, I'd agree with that. I think contributory negligence, unless it's sort of a full concession, I don't see that being suitable. There's a question in terms of reallocation and reassignment. The costs have been noted. Would this be the case if a Part 36 offer had expired in one track band but had since been reallocated/reassigned? That's an excellent question, because the rules, even though they sort of say, well, you assume the costs are this from the outset, again, I think this is one of those things where it's actually going to be quite significant in considering offers quite carefully. Because if you then later go and accept an offer out of time and you're now allocated to a different band, you may be on the hook for more costs. So I don't have a definitive answer to that, but I can very well see a scenario where if it's subsequently been reallocated, because what the wording in the rule says is basically treat it as though it was that from the outset, that is likely going to follow through in terms of Part 36 consequences. In terms of what is the position if liability is denied, necessitating further work and then admitted later, does the claim fall back into Band 1? The court can reassign of its own motion or on an application from the parties. I would consider that to be
I think it depends when. If it's pre-action, then I think it's probably just going to be, and it's admitted pre-action, there will be band 1. If the issue's been rumbling around for a bit, I think reallocation is going to be a bit less likely.
The way I understand the rules as they are about reallocation and reassignment is it's really trying to discourage things moving once the sort of directions have been set and the progress of the case is undergoing. So, and especially the closer you get to trial, I can see there sort of being a lot more reservation from judges to start sort of tinkering, even though they might not need to tinker with the directions, but even just tinkering with the banding. So it is one of those as well where actually, if the issue has become narrowed and it was unreasonably narrowed at a certain point of time.
But I mean, again, if we're looking at the cost from the outset, it just does not seem to be following basic principles of justice, where someone has been having to defend or multiple issues, and then one drops away, and then you say, well, there's only one issue now, you get far fewer costs.
Yeah. Well, I think that was all the questions that we had. Thank you very much for joining us this afternoon, and we hope that you have found this talk to be useful. Yes, thank you very much.
Thank you.